Hello, good evening to one and all. Today I am going to talk about Indian constitutional law new challenges. In this there are few topics which I would like to cover for today's class. So the first one is federalism. Federalism, that the Federalism Constitution, a complex governmental mechanism for governance of a country, it has been evolved to bind into one political union several autonomous, distinct, separate and administrative units. So both federal and state governments derive their powers from the Constitution. Both are separated in particular spheres and both operates directly on the people. A federal state requires a written constitution, and approximating governmental responsibilities both the central and the state governments, and conferring the balance on the states or conversely. So it is also necessarily implies judicial review, as the possibility of ultra vires legislation must be considered. So the advantages of federalism are that it frees the federal government for consideration of national and international issues, gives states and provisional governments measures of independence and ability to devise their own solutions for local problems. So the disadvantage are that it's create a very complicated and legislative structures with much opportunities for disputes between federal state governments on power and their exercise. So the federalism which founded not on the rule of law but on the supremacy of the written constitution. So the English concept that the rule of law, which might inspire the framers of the American constitutions, but they transfer that concept into a totally different ones, that the supremacy of the constitution, and instead of the law laid down by legislatures, and therefore the legislatures under the American constitution came to be treated as non-sovereign. So for the first time in the history of the world forms a constitution which should in strictness the law of the land, and in so doing created modern federations. The prime example of a federal states in the modern world is the United States of America, which comprises a federal government and 50 state governments, all 51 having legislative, executive and judicial organs. So the federal states are variously called confederations, federations, unions, and sometimes by other names as per the government decides. So for the supremacy of the written constitutions, which involve the various elements which has been drawn from the American Constitution. Written constitution is a higher or superior instrument from which all the organs of the state drawn their respective powers and are limited thereby. So it is not possible that therefore for the legislature to claim absolute or unlimited powers as the British Parliament. The supremacy of the Constitution is protected by the authority of an independent judicial body. So for this, to act as the interpreter and arbiter of the scheme of distribution of power, made by constitutions, the function popularly known as the guardian of the constitution. The distribution of the power made by the constitution must be guarded by the judiciary, which is to interpret the constitution as the fundamental law of the land and to enforce its provisions against both federal and regional governments and to invalidate any of their acts which transgresses the limitations imposed upon them by the constitution. So all functionaries under the constitution which take oath to uphold the constitution. Constitution constitutes the higher law which has to be interpreted and applied by the court of law. Article 141 in the Constitution of India says that the law declared by the Supreme Court shall be binding on the courts within the territory of India. In this article, the Supreme Court enjoins to declare the procedural law as well as the substantive law, and the term declare is said to be the wider one. It has been specified that to declare means to announce a particular opinion. Indeed, the term made involves a process, while the term declare which express a result. So it is precedent for itself and for all courts and authority in India. Doctrine of precedent is here. So the Supreme Court plays its role as the guardian and the constitution through its powers of final interpretation. Where the federation states have separated constitutions and the problem arises as to how far constitution's decision of the federal Supreme Court shall be binding upon the states and the courts. Even the case law is also there in Article 141 that Ahmad Khan versus Shahabanu Begum, Shamrao versus Union Territory of Pondicherry, Caspal Company Limited versus Borem, Denial Latifi versus Union of India. So these are the cases with directly related Article 141 in the Constitution of India. Now when the federalism is concerned, we have to study for the Canada, because Canadian federalism is no longer of the highly centralized form as to was in 1867, with the powers of the states confined to the matter enumerated in section 92 and this residuary belonging to the Union, section 91. In the Constitution Act of 1867, the only concurrent subjects was immigrations and agriculture, that is for section 95. So the scheme of distribution of powers in Canada between the central and the provinces makes a threefold enumeration of powers. And the center is empowered by section 91, 30 specific head which I mentioned here few only: defense, postal service, currency, coinage, taxation, criminal law, regulation of trades, commerce, unemployment insurance, of the British North America Act 1867 to make laws for the peace, order and good governance of Canada. So section 92, which is important for the regarding federalism is concerned. So section 92, which empowers the provinces to legislate exclusively with respect to 16 subjects. Section 95 says agriculture and immigrations, which are concurrent subjects with supremacy in favor of the central in case of conflicts between a central and a provincial law. Provincial means a state law. The British North America Act was intended to establish a strong center, and the growth of the Canadian federations has been too much influenced by the existence of biracialism and bilingualism in the country. The English speaking people in a majority of the country wants to strong center where the French-speaking minority desire a weak central and strong provinces. The central government in Canada face great difficulties. Section 132 of the British North America Act says Canadian Parliament has necessary and proper clause for the power to perform the obligations of Canada, which is a part of the British Empire. In 1876, when the British North America Act was passed, Canada was a British colony with no international status. But today, Canada enters into treaties as a sovereign country. And the case is also related for this colonial sugar refining case in 1914. Then Canadian Constitution Act, which is as per this, comparing Canada Constitution Acts and Australian Constitution is federal in the strict sense of the term. The Canada Constitution could be called federal only in a loose sense of the term. So, the United States of America. In the USA, the federations came into existence as a result of a voluntary act between 13 sovereign states. And the Constitution of the United States of America was brought into being in 1787. And of course, it is the oldest and the most respected members of the family of modern federal constitution. The constitution adopts a very simple method for central state distribution of powers. Whereas in the United States of America, the process of centralization has been aided by the Supreme Court by way of liberal interpretations of the federal powers of interstate commerce and general welfare, or the supremacy clause in Article 4. The 4 is a Roman, they use 4 subclause 2 or defense Article 1, as well as by inventing the judicial doctrine of implies power of the federal legislatures, national pre-assumption and judicial recognition of cooperative federalism in the United States of America. It has only one list specifically enumerated the powers of the center, and few enumerated or specified power has thus been allocated to the center, and the unenumerated residues of power has been to the states. So the Supreme Court has developed the doctrine of incidental and ancillary power, which is says necessary and proper clause, after sometimes known as the coefficient clause. Then we go for the comparison between this Canada and the India. So the Canada is guided by both written and unwritten law, whereas India is guided as by the written constitution. We say text. So the provisions of federations with a strong center, residuary power of the central, appointment of state governors by the central, and the advisory jurisdictions of the Supreme Court, which have all been borrowed from the Canadian Constitution. So the main two difference between the Canada and the Indian is, one is emergency situation, where the Canada has only general power, becomes much more meaningful, whereas in India, when an emergency is declared, the central becomes entitled to legislate with respect to any matter in the state list. As per the treaty is concerned, India has the comprehensive power to give effect to the treaty, even in the subject matter falls within the state list. So in Canada, the center is restricted to some extent in this area. Comparing between USA and the India. So in USA, there is only one list, while there are 3 lists in India. in America only the exclusive powers of the centrals are defined. There is no concurrent list and the residuary vest with the states. In India, the exclusive powers of the central as well as the states are defined, but the residuary vests in the central and not the state and has a large concurrent areas. So about the function in India are much more numerous and broader than in the United States of America. Then Australia. The Australia Constitution Act 1900 was framed on the model of the American federal system of grant of enumerated powers to the Union and residuary powers in favor of the state and judicial review to maintain this division of powers. The Commonwealth of Australia, which joined this family of federation in the year 1900, specific powers to the central. When the British Parliament enacted the Commonwealth of Australia Constitution Acts, it follows the American model to the extent of giving only. So section 51, there is 40 heads of the Commonwealth Act with respect to which the central parliament has power to legislate but does not make power of the central exclusively in the Australia. In case of inconsistency between a central law and a state law, the central law prevails and the state law is invalid to the extent of inconsistency. And the power of centers are defined and specific. So the central has full control over external affairs and it can make a law in subject matters fall under the state jurisdictions. We're comparing between the Australia and the India. In India and Australia, both countries have exclusively powers to the central. Comparing to both countries in India, Union list is much more exhaustive and much larger than in Australia. In Australia, the powers of the states are unenumerated and defined. In India, it is not so. So in India, residuary vest in the central, whereas in Australia, the residuary vest in the states. In India, so the Indian Constitution. Indian Constitution is of a federal type. It established a dual polity, a two-tier government system with the central government at one level and the another one is the state government. The scheme or distribution of Indian Constitution of legislative, administrative and financial powers between the central and the state. A state government is entitled within its field and not to encroach on the field of the other government. Since neither the federal nor a state legislature under a federal constitution is subordinate to or a delegate of the others. Subject to constitutional limitations, if any, either the union or a state legislature may make laws of the following nature relating to a subject which is within legislative competence according to the distribution of power made by the Constitution. So Article 245 to 254, Schedule 8 of Indian Constitutions has given the distribution of powers. Whereas the federation is there, so India is a member of the family of federation, of which the better known member are these United States of America, Canada and Australia. So instead of the word federation, the word union was deliberately selected by the drafting committees of the Constituent Assembly to indicate two important things. So the one is that the Indian Union is not the result of an agreement by the states, and the second, the component states have no freedom to secede from it. That is why whenever the topic of federation or federalism is concerned, we have to go to for Canada, USA and the Australia. Then we came to know why we call union in Article 1 of Indian Constitution. So Article 1 says, name and territory of the union. India, that is Bharat, shall be a state of union of the states, union of states. So India is a dual polity but has only a single citizenship. American USA has dual citizenship. India has a uniformity because if any accident will took place in any of the state, CPC, CRPC or the others act and law is applicable. It's a uniformity. It is not so in the America because the different state has different constitution. So the accident took place in one place, you cannot claim to the other one. And before 1935, unitary states and a uniform system above act, but the constitution places this in the concurrent list. So the federalism, which has been declared to be an essential features of the constitution and as a part of its structures, where they call written constitution, separation of power, then judicial review, all these are essential feature of Indian constitution. And the way of unitary one, then we have to go for the central authorities, and of course after central authority every regional authority will come. So for the next one is freedom of press. Freedom of press, it is directly, if you go freedom of press, we have to know, yes, it is a personal liberty, it is the most important of all fundamental rights. Article 19 to 22 deals with different aspects of this basic rights. These articles are the backbone of the chapter of fundamental right part 3 of the constitution. And Article 19, freedom of speech and expression, includes freedom of press. And this are 6 freedom in Article 19, which is not absolute. So absolute fundamental rights cannot be guaranteed by any modern state. So in common parlance by press, but in media law, press means print media, like a newspaper, journal, magazines, periodicals, pamphlets, leaflets, bookstore, any other printed material like handbills, document, etc. Even news agencies, press syndicates and feature agencies form part of the umbrella of the term of press. It is a source of entertainment and also serve as a medium of advertising and publication. Where we go that the rights which has given in Article 19 are restricted by the Constitution in clause 2 to 6. Even though you have a freedom of speech and expression, freedom to move one place to another, you have to follow some restriction, and that restriction has been given in clause 2 to 6 in Article 19. The restriction can be arbitrary, even it satisfies 2 valid conditions, and everywhere it satisfies 2 valid conditions. So the first one is the purposes mentioned in clause 2 to 6 of article. What is the purpose of mention this restriction? And the second, the restriction must be a reasonable restriction. So the clause A to G in Article 19, these all are your freedom. You have to enjoy speech and expression, peaceable assembly, association, free movement, residence. F, it is repealed. And G, for practicing any professions and carrying on any business. So these freedoms not only to promote certain basic rights but also democratic and unity of the country. In A.K. Gopalan case, where Justice Patanjali observed that a man has a rational being and desire to do many things, but how to do control and regulate it and reconcile with the exercise of similar desire by other individuals. So in writings of the wall and on stone during these periods, which dating back to several centuries before, like crest were the first sign of the origin of press in India. Emperor Ashoka, the edicts are available to this day on stone, and later paper and writing materials were invented. State records in the form of message from speeches were maintained. So the newsletter were regularly issued during the Mughal period. The practice seems to have been continued until the East India Company, which arrived in India. So in this case, in A.K. Gopalan, where specifically mentioned that a person has a discretionary power to enjoy. But if a person has discretionary power, so after some time the person can be misuse that power. That is the reason we need restriction. That's what Article 19 subclause 2 to 6 has been given the restriction. So these articles, that the fundamental rights, somewhere it is called basic rights, somewhere it is called natural rights, great rights, birthright, legal right. Originally Article 19, which guarantees 7 freedoms, and in 44th Amendment 1978, to hold and acquire property, it was repealed, and it's controlled by Parliament to the state legislature. As far the freedom of press is concerned, the first printing press was established in Bombay, because that time it's called Bombay, not in Mumbai. So in Bombay in 1674, second in Madras in 1772, and third in Calcutta 1776. So the first Indian old newspaper was the Bengal Gazette in 1780, started by Gangadhar Bhattacharya. And now the press is several Indian language which has started, making rapid this sign like Urdu, Marathi, Gujarati, Tamil, etc. So the number of legal instructions were imposed on press by the British rulers. And the first 2 decades of the 19th century, which saw rigid control of the press by Lord Wellesley and Warren Hastings. In 1889, when Lord Curzon took over as Governor General of India, number of enactment of the India Official Secrets Act was passed in 1889, and the Press and Registration of Book Act 1867 passed, Indian Penal Code 1860. And in this Indian Penal Code, section 124A and 505, which has created tremendous difficulty for the way of press. So what is the main and object of this freedom of press? To promote intellectual self-expression by and social intercourse among citizens. The preservation of the spirit of unity by encouraging free movement throughout India and increase national productivity. So for this freedom of press, Article 19, which confer fundamental rights on citizens only, foreigner does not allow. Why it is mentioned this foreign does not allow? Because in fundamental right there are few articles which foreigner enjoys as our Indian enjoy. So Article 19A, this is the case where to reside and settle in India, where Losi D. Riols versus Union of India, Article 1991, AR 1991, Supreme Court 1886. In this case, a foreigner came to India in 1937 with this Belgium passport and Christian missionary work. When the country issued one press or the Gazette Order 87/1987, and according to that order, that the person has to move their country. So in 1807, and the person came in India in 1937. So after 50 years, he got order by the country that you have to leave the state, particular state where he was there. He filed a petition before the Supreme Court that he is applicable in Article 5. Article 5 says citizenship at the commencement of the Constitution. As per his petition, Supreme Court rejected and mentioned the reason that Article 5 says that after the commencement of the Constitution, a person who was born in the territory of India, either of his parent was born in the territory of India or not less than 5 years immediately preceding such commencement shall be a citizen of India. And as I mentioned that after 50 years, the person has to get a citizenship from the country, but he didn't. So that is the reason his petition was rejected by the Supreme Court. Now the next is Anwar versus State of Jammu and Kashmir. This is the case where a foreigner enjoy Article 21. And what Article 21 says? That no person shall be enjoy their life and personal liberty except established procedure by laws. So the Article 21 is the right to life and personal liberty. This in Article 21 says, in this case of Anwar. But in freedom of speech and expression or even the freedom of press, there are some reasonable restriction which has to be applied in almost all cases. What the exact definition says? Definitions mean what exactly article says. Judges on its own merits on the basis of facts and circumstances. No abstract standard will be there. And if the restriction imposed by law, not the executive and the department. Intelligent care with reason dictates whatever the pass any decision, the reason must be there. And whatever the clause mentioned in Article 19(2)(6) has been applicable. So court decides, not the legislature, whether it is reasonable or not, but rights enjoyed by individuals and has control clause 2(6) in Article 19. Where freedom of speech and freedom of expression, these are two concepts. When one is a political rights, so another one is synonymously. Freedom of speech is to communicate one's opinion and idea. It is not absolute in any country. Even the limitation is also provided. Example of, I mentioned here, slender and leopard. Whereas in expression, receiving information and ideas, medium use, freedom of expression is recognized as a human right, which under Article 19 of the Universal Declaration of Human Rights and ICCPR, International Covenant on Civil and Political Rights. So the case law says, the first one, case laws N.B. Khare versus State of Punjab. Here mention that the restriction must be substantial and procedural standpoints, whatever the restriction. State of Bombay's case said that restriction must be object and laid down by the directive principle of state policy. Whereas Narendra Kumar versus Union of India's case said special care has to be taken by the court, test of reasonable whether it is a satisfy or not. State versus Charity is one of the case where interview of under trial prisoner. Whenever you take interview of under trial prisoner, there is no required to publish in the newspaper or any of the media, social media. You have to take a permission, and while the case is proceeding, you have to take a permission from the concerned court where the case is pending, as well as the superintendent of this particular jail. Freedom of press, whereas United States of America, the First Amendment mentions a free press, and they say that we have three institutions: legislature, executive and judiciary, and the fourth one is the press. And they started American Press Commission because of political liberty. Indian Press Commission, here democracy can only enjoy the vigilant eye of its legislature, but public opinion. So the freedom of press. In 1795, censorship was introduced for the first time, and this censorship continued until 1799, when the first press regulations were promulgated by Marquis of Wellesley. Warren Hastings abolished these regulations. So the press commissions after independence, the first press commission report was set up in 1954 and the second press commission set up in 1982. But as where freedom of press is concerned, there is no specific provision in Indian Constitution which includes freedom of expression. And the Supreme Court stated that freedom of press is a democratic society. So, freedom of press and challenges of new scientific development. Freedom of press or freedom of the media is a freedom of communications and expression through medium including various electronic media and published material. While such freedom mostly implies the absence of interference from an overreacting states, its preservations may be sought through constitutions or other legal protection. The Universal Declaration of Human Rights states about the freedom of press that everyone has the right to freedom of opinion expression. These rights includes freedom to hold opinions without interference and impart informations and idea through any media regardless of frontier. So not only UDHR has given the freedom of press expression include in this declaration, we have other also. When we go for history in Europe, Western Europe, has a long tradition of freedom of speech, including freedom of the press. The Geneva Conference on Freedom of Information in 1948 but were blocked by the Soviet and by France. Great Britain, according to the New York Times, that Britain has a long tradition of a free, inquisitive press, but unlike the United States, Britain has no constitutional guarantee of press freedom. When the Italy, after the Italian unification in 1861, the Albantine Statute of 1848 was adopted as the constitution of the Kingdom of Italy, and the statute granted the freedom of the press with some restriction in case of abuses and in religious matter, as stated in Article 28 in this statute. Where in United States, the Bill of Rights states, Congress shall make no law respecting on establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press. Whereas Sweden, one of the world's first Freedom of the Press Act was introduced in Sweden in 1766, mainly due to the classical liberal member of parliament, that is for the Anwar. Freedom of speech. So, freedom of speech is the right to communicate one's opinion and idea without fear of government retaliations and censorship. The term freedom of expression is sometimes used synonymously but includes any act of seeking, receiving and imparting informations or idea regardless of the medium used. Whereas origin of freedom of press and expression, which has a long history, that in the period of international human rights instruments, because in the international instruments also we know that the Athens democratic ideology of free press may have emerged in the 6th or 5th century BC, and the value of the Roman Republic includes freedom of speech and freedom of religion. Freedom of speech and expression. That the concept of freedom of speech and expression can be found in early human rights document, which I mentioned, UDHR, ICCPR. England Bills of Rights 1689 legally established the constitutional rights of freedom of speech in Parliament, which is still in effect. The Declaration of the Rights of Man and of the Citizen, adopted during the French Revolution in 1789, specifically affirms freedom of speech as an inalienable right. Then the declaration provided for freedom of expression in Article 11. The free communication of ideas and opinions is one of the most precious of the right of man. Every citizen of man, according to speak, write, print, whatever, but shall be responsible for such abuses of this freedom as shall be defined by law. Article 19 of the UDHR of adopted for the freedom of opinion, freedom of expression, and this rights includes freedom to hold opinions without interference and to seek, receive and impart informations and idea through any media and regardless of frontier. So of course it is a coincidence that in Indian Constitution as well as UDHR is the same article 90. Then the today freedom of speech or the freedom of expression is recognized in international and regional human rights law, and the right is enriched in Article 19 of the International Covenant on Civil and Political Rights. So of course again here Article 19 ICCPR, UDHR and Indian Constitution, same Article 9 say about the freedom of speech and expression, directly include freedom of press. Article 10 of the European Convention on Human Rights, Article 13 of American Convention on Human Rights, Article 9 of African Charter on Human and People Rights. Based on John Milton argument that freedom of speech is understood as a multifaceted rights that includes not only the right to express or dissemination informations and idea, but there are three main aspects of the rights: the right to seek informations and idea, the right to receive information and idea, and right to impart information and idea. So there are the case in this, but of course there are again one is right to strike, hartal and burn, because in India right to protect is a fundamental rights under Article 19 of the Indian Constitution. But that right to strike is not a fundamental right but a legal right. And with this right, statutory restriction is attached in the Industrial Dispute Acts 1947, which Band is originally a Hindi word meaning closed, is a form of protest used by political activists, South Asian countries such as India and Nepal. Freedom of press. So in this freedom of press, we have so many cases here. I would not be, as per this, go in very much detail. I just put here for the citation that in Sakal Paper Limited versus Union of India, this is regarding for the price and control, daily newspaper order 1960, because if there is a minimum pages, number of pages must be less or the high. So this was the case. Prabhu Dutt versus Union of India. This is case regarding newspaper reporter can interview the prison and condemned to death if they are willing to be interviewed. Ramesh Thapar versus State of Madras. Indian Express newspaper versus Union of India. Bennett Coleman versus Union of India. Hamdard Dawakhana, Odissi Communications, Life Insurance Corporation of India. So these are some of the cases which is directly focused on freedom of press, freedom of speech and expression. Naresh Mirjakar, this is the case where the evidence of a witness should not be published in the newspaper. Its effect, his life, his family, and of course somewhere in our regulation too. Rajgopal versus State of Tamil Nadu, this is the case of state officer. Prior restriction on publication of any material in the press, it is defamatory of the state of its officer. Because if a state officer, state government officer, he has to follow some regulations. And without his consent, if the publication will be there, his job has been suspended immediately. So without permission of this state officer as well as the higher authority where he is doing job, it is impossible, it is completely restricted that you have to take first prior permission of the concerned authority and then you can publish. Then we move on next topic for the right to equality. As for the equality, in Indian Constitution, Article 14 to 18 says equality is one of the magnificent cornerstone of Indian democracy. Article 14 of the Indian Constitution 1949 says that equality before the law. The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of Indian prohibitions of discrimination on the ground of religious, sex, caste, etc. So in this article 14 to 18, we have these articles: equality before law, prohibition of discrimination on the ground of race, sex, and equality of opportunity, abolition of untouchability, abolition of titles. So the right to equality is one of the chief guarantee of the Constitution. It is embodied in Article 14 to 16, which collectively encompass the general principle of equality before law and non-discrimination. Because Article 14 says equality before law and equal protection of law only, but Article 15 creates discrimination, that discrimination not be there. As per Article 14 say, equal will be there, equality will be there. Whereas Article 17 to 18 says collectively further the philosophy of social equality, titles, untouchability. So the origin, the first expression that equality before law is of English origin, and the second expression, equal protection of law, has been taken from the American Constitution. Right to equality present almost all written constitutions. United States of America, West Section 1 to 14. Amendments say no state shall down to any person within its jurisdiction the equal protection of the law. United Kingdom say no fundamental rights, no room for challenging judicial decisions, but only limitations against state action of any kind. There are different countries which says about the equality. Burma section 13 says that equal before the law, that is to say like any arbitrary discrimination between one citizen or class shall not be there. I'd say all citizens as human person be held equal before law. I'll say all inhabitants of the republic are assures equality before the law. UDHR Article 7 say all are equal before the law, are entitled without any discrimination to equal protection of the law. In this UDHR, when you read very carefully, we can observe here that freedom of speech and expression, that both expression include here UDHR. But somewhere is only for the freedom of speech or somewhere is only for the freedom of expression. But almost all written constitution, both expressions are there. Equality before law, the first is a negative concept, that there is no special privilege in favor of anyone, that all are equally subject to the ordinary law of the land, and no person, whatever be his rank or condition, is above the law. Whereas equal protection of law is a positive one. The same law should apply to all persons. Every law must have a universal application within the country. Differences of circumstances, equal the law should be equal and equally administered. That the like should be treated alike without distinction of race, caste, sex, etc. So both have a common justice, both have a common respect. Rule of law. When we start this equality, without discussing rule of law, that topic is not complete. So the guarantee of equality before the law is an aspect of what Dicey say. Dicey in England, he means that no man is above the law. That every person, whatever be his rank or condition, is subject to the jurisdiction of ordinary court. Absence of arbitrary power or supremacy of the law. equality before the law and individual liberty. So as per the Dicey in Indian Constitution, we are accepting one point and the second one, that is absence of arbitrary power or supremacy of the law, and the second is equality before the law. The third one is individual liberty is not applicable in India. So the any person, any company, association, body of individuals, citizens and non-citizens to natural person as well as legal one, there are exception of rule of law because it does not apply to private citizen. Rule of law does not prevent certain classes of person. Member of armed force, medical practitioner, president or the governor. In medical practitioner there are some specific act that applicable to medical practitioner. Whereas armed force, the military man. So you heard the word of court martial and all. So difference of this classes, different act is applicable. There is again a discretionary power which other minister emergency like suspended Article 20 and 21 at the time of emergency. So if the suspension is there, so obviously rule of law is also suspended. Then the cases. These are the cases while or including in right to equality. State of Bihar, Bihar Lecture Association, trained and untrained teacher. The discrimination was there, trained and untrained teacher. So this was the case. E.P. Royappa, where the new dynamic concept of equality, that is equality must there but not be arbitrary one. Maneka Gandhi case, landmark case, everyone knows that. Vishaka versus State of Rajasthan. Air India case, air hostess case. Narges Mirza. R.D. Shetty case versus International Airport Authority. This is the one of the landmark case we can say because the doctrine of classification which is involved by the court is not in paraphrase of Article 14. That in this case the court has passed test of reasonable classification say that any of the case go before the court of law under Article 14, these reasonable classification has to be applied. First one is that intelligible differentia. I mentioned just now trained and untrained teacher, the one of the case, that is intelligible differentia. The second is rational relation. Single individual may be treated as class itself because a single individual related to the family related to the society and society related to the one of the state. There is no classification geographical, scientifically, mathematically does not require in this right to equality. So the doctrine of classification is merely a judicial formula which determining some classification is important whether the legislative or the executive action is arbitrary and therefore constitute a denial of equality. So we can say in the right to equality that justice should not be done but it must also be seen to be done. So the next one is state. What state? In Article 12 of Indian Constitution, that most of the fundamental right are claimed against the state, and in instrumentality and not against private bodies. So the two important concepts, state and the law, is important while we discussing state. So the definition of state, Article 12 says, state includes the government, the Parliament of India, the government and the legislature of each of the state, all local and other authority within the territory of India or under the control of the government of India. So important in this Article 12 is Parliament of India is defined, somewhere rules, regulation we can know. State governments also, the local government, municipality, panchayat, roads. But every time it is an interpretation in other authorities. Whether it is a firm, whether it is a company, whether it is a trust. But it's not clear yet. A decision by the court wise, we came to know that yes, this point come under other authority under Article 12 or these are not. So Article 13. Directly we jump Article 13 because if the state is there, we have to go through laws also. So law. Article 13 say laws inconsistent with or in derogation of the fundamental rights. Pre-constitution and post-constitution. So in first one, that all laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provision of this part, shall to the extent of such inconsistent be void. Whereas post-constitution said, the state shall not make any law which take away or abridge the rights conferred by this part or any law made in contravention of this clause shall to the extent of the contravention be void. So the pre-constitution say immediately before the commencement of the constitution. Where Article 13.3 says, Article 13.3a, which law? Law includes any ordinance, order, bylaw, rules, regulation, notification, custom or usages having in the territory of India the force of law. So where the state is there, Article 12, Article 13.3a, small a, define definition of law. Law in force, which includes laws passed or made by our legislature or other competent authority in the territory of India before the commencement of the constitution and not previously repealed. Notwithstanding that any such law or any part thereof may not be then in operation either at or in any particular areas. But nothing in this article shall apply to any amendment of this constitution made under Article 368. So the Article 13. The action of any of the bodies which comprises within the term state as defined in Article 12 be challenged before the court under Article 13.2 on the ground of violating fundamental rights. So the most significant expression used in Article 12 in other authorities. And this expression is not defined in the Constitution. It is therefore for the Supreme Court is defined, the term is more and more bodies can be brought within the discipline of fundamental right and of course for the case laws. For this purpose, Supreme Court has developed the concept of an instrumentality of the state. So for the other authority, somewhere it's called instrumentalities. Any body which can be regarded as instrumentality of the state fall under Article 12. The emerging principles which appear to be that of public corporations being a creation of state is subject to the constitutional limitation of the state itself. So for the case laws, Sukhdev Singh versus Bhagat Ram, this is the case where three statutory bodies called under the authority, which came under the authority. ONGC, LIC and Finance Corporation, which held to be authority. Rajasthan State Electricity Board versus Mohanlal. In this case, Supreme Court ruled that a state electricity board set up by statute and it's come under the Article 12 as authority. Then Ramana D. Shetty, International Airport Authority. The question was considered more thoroughly and Supreme Court developed the propositions that an instrumentality or agency. So again the new word came here, that agency of government would be regardless as an authority or state within Article 12. Though the question of statutory bodies has been settled, at that of the non-statutory bodies still continue to cause confusions and difficulties. The question was finally clear in Ajay Hasia case, where the Supreme Court held that where a corporation is an instrumentality or agency of the government must be held to be an authority under Article 12. And in this case, Supreme Court laid down some following important tests which I mentioned, that a body is an instrumentality of the government or not, we have to follow this test. First, whether entire share capital is held by the government. Financial assistance given by government is so large. Deep and pervasive state control functions performed are of public importance. Body enjoys monopoly status, and the main test which the courts apply to determine whether a body is an instrumentality of the government or not are finding and control. So the non-statutory bodies case, Vibhu Kapoor versus Council of ISE examination. This is the case of the Council of the Indian School Certificate Examination. Manmohan Singh versus Commissioner United Territory Chandigarh, P.K. Ramachandra, All India Sainik School employee. So these are the cases where non-statutory. Sheila Barse versus Secretary Children's Aid Society. This is the case in Bombay. So Ajbul versus Lilaram case. Federal structure of the Indian Constitution. Part 1 say the Article 1, India, that is Bharat, and shall be a union of states. So Article 12, Article 13 and Article 1. Article 3. Article 3 said that formation of new states and alteration of areas, boundaries or name of existing states, Parliament may by law. So the form or new states by separation of territory from any state or by uniting two or more states or part of states or by uniting any territory to be a part of any state. And second B, Article 3 says, increase the area of any state, diminish the area of any state, alter the boundary of any state and alter the name of any state. So Article 2 also say admission or establishment of new states. So the Parliament may by law admit into the Union or establish new states on such terms and conditions as it think fit. But when you go for explanation in Article 2, there is a two main important in this article. That the first one is to admit into the Union new state, which means they are formed and established already in existence, already is there. And the power to establish new state, the second one says that admission and formation of a state which was not in existence before. That means it's created completely new. And the earlier first point, it's already is there and you have to some like alter, some diminish. Now as per Indian Constitution, so in this Indian Constitution that federal say neither to subordinate to other, unitary is like power in law to overrule, part 11 say relation between the union and the state, Article 245 or 263 mention three list state, central and the concurrent. Article 248 says residuary powers and Article 249 and 250, 251, these all are inconsistency, interstate disputes, boundary, Maharashtra and Karnataka, Tamil Nadu, Andhra Pradesh, water disputes. So Article 250 and 251, that is for the inconsistency between the boundaries. Whereas the England is the mother of democracy, that without basic rights, there is no basic rights, it will become meaningless. But England is an unwritten constitution and there is no code of fundamental rights. Whatever action, so long as he does not violate any rule of law, there is ordinary law of the land. And England's code is omnipotent supremacy of the parliament. Whereas in USA, legislature, Congress, executive, president, judicial, Supreme Court, president power is a veto one, overridden only by two-thirds majority in both houses, Bill of Rights, and equally binding upon legislature and executive, judicial supremacy. Then empowerment of women. See, empowerment of women we directly cannot touch in Indian Constitution. Before that we have to go in some Vedic period where women during this early Vedic period enjoy equal status with man in all aspects of life. Work by ancient Indian grammarians such as Patanjali or Katyayana where suggests that women were educated in the early Vedic period. Rig Veda verses suggest that women marry at a mature age and were probably free to select their own husband. Scriptures such as the Rig Veda and Upanishads mention several women sages and seers, notably Gargi and Maitreyi. So, in 500 BC, the status of women began to decline. And the practice of child marriage is believed to have started around the 6th century. And the medieval period, where the Razia Sultan became the only woman monarch to have ruled Delhi, and the goat queen then Durgavati ruled for 15 years before losing her life in a battle with Mughal Emperor Akbar, General Asaf Khan in 1564. Chand Bibi defended Ahmednagar against the powerful Mughal forces of Akbar in the 1590. Jahangir's wife, Nur Jahan, effectively widespread imperial powers and was recognized as the real power behind the Mughal throne. So Sati, then Johar, Parda, Devdasis. These are some of the earlier important aspects when we go through for the empowerment of women. When the British rule is there, during the British Raj, many reformers such as Rajaram Mohan Rai, Ishwar Chandra, Vidyasagar, Jyotiba Phule, which fought for the betterment of women. And Rani Lakshmi Bai, the Queen of Jhansi, led the Indian Rebellion of 1857 against the British. So Vijay Lakshmi Pandit, Rajkumari Amrit Kaur, Aruna Asaf Ali, Sachita Kirpani and Kasturba Gandhi, they play important role during the British rule. Women in India after independence is now participate fully in areas such as education, sports, politics, media, art and culture, services, science and technology, etc. And these are the articles in Indian Constitution where the woman can directly claim. Article 14, 15.1, 16, 39, small d, 15.3, 15, capital A, small e, Article 42. So the Government of India declared 2001 as the year of women's empowerment. That's was Shakti. The national policy for the empowerment of women was passed in 2001. Other international empowerment of women like the Charter of UNO 1945, UDHR 1948, Convention on Political Rights of Women 1954, ICCPR, ICCR 1966, the Declaration of Mexico, the Convention on Elimination of all form of discrimination against a woman. These all are conventions, international conventions, where everywhere women's articles are there related to women empowerment. Charter of UNO 1945, Article 8 says no restriction on the eligibility of man and woman to participate. UDHR Article 1 says all human beings are born free and equality, dignity and rights. Article 7 says equality before law and equal protection of law. Article 12 protection of privacy. Article 16 right to marry. Article 23 equal pay for equal work. 25 right to have a standard to living. So there are so many articles in UDHR. Not only UDHR, even the other international covenant and the protocol too also. Convention of Political Rights of Women 1954, Article 1, 2, 3 specific for right to vote without discrimination, eligibility for election, right to hold public, on equal term with man. ICCPR, right to marriage, right to citizen, equality, equal before the law and equal protection of law. ICCR, states shall ensure equal right to man and woman. Declaration of Mexico. Declaration of Mexico is not create some of specific article. There is mentioned some principle, right? Equality between man and woman. Point A, B, C, D. Likewise, equal pay for equal work. Right to every woman to decide freely whether to marry or not. And of course, this is the continual participate to contribution, participate of women in the economic, social and cultural sector. CEDAW, 1981. States shall condemn discrimination against women in all states shall take all measures to ensure the full development of women. States shall take all measures to suppress all form of trafficking in women. And these are our Indian Constitution article. Other empowerment, criminal law also, the adultery, cruelty, unnatural offences, etc. CRPC also provide empowerment of women. These are so many acts. I say here so many, I am not counting here, but apart from this also there are few acts which I couldn't include here. Prohibition of child marriage, women property, Women's Under Factory Act, traffic offences, prohibition benefits, so article regarding for empowerment of women. This is the 3 landmark case which I include here. But not only there are so cases, or there are so many cases. Sarla Mugdal, Vishaka and Maneka Gandhi case regarding empowerment of women. So, even not only for this empowerment of women, we have lot of things that if we start for the study of empowerment of a woman, it will take lot of time to study, because as per the Indian Constitution is concerned, there are article, and then we go for the other instrument. We are so many articles that like comparatively it's quite equal, the similar one. But the thing is, even for the 21st century we are dwelling here, still somewhere we are facing that empowerment of women. So,
1 hour 24 minutes.
almost left.
For 1.5 hours.
Okay, so I think I should stop here, because there are 2-3 more points, but if I will continue, it will take again 1 hour time. So I just requesting to all of you, please comment in this description box. So which type of you like, for only explanation, or you want with the PPT explanation? Because in the PPT explanation I just focus for the main important point. I could not go in very detailed one. Whenever there is explanation, we can go a little bit in much more detail. So thank you so much all of you to being with me here. Thank you for watching. Please like and subscribe, and please drop a comment box as that which point I should be covered. I miss here for the 3-2 point that secularism is more important, and of course there are 2 religious fanaticism is also one of point that I would like to cover, but as the time is not permit here, so next time I will try to prepare the next schedule if time will permit, and I will give you the more guideline and the important thing regarding the topic. So thank you so much all of you to being here. Thank you.